Hey guys, attorney Jerry Parisi here, and today I'm answering the question, what is the statute of limitations on credit card debt in Georgia? So first, what is a statute of limitations? What does that even mean, and why does it matter? Well, basically the statute of limitations prescribes the deadline that a plaintiff has to bring a lawsuit against you. So in Georgia, it's 6 years on credit card debt. And how do I know that? Well, because the law is OCGA 9-3-24, and that's the law that prescribes the statute of limitations on written contracts. And here's what it says. All actions upon simple contracts in writing shall be brought within 6 years after the same became due and payable. So you may be thinking, well, I don't have a written contract with the credit card company. I've never signed anything. They don't have my signature on file. So how could it be 6 years? How could it be subject to this particular law? Well, guys, Georgia courts have held that credit cards constitute written contracts here in Georgia. They say that when you receive a credit card in the mail, you use that credit card, and the credit card came with terms and conditions that, this legalese that they put in the envelope, that all creates a written contract. So it's subject to the 6-year statute of limitations under 9-3-24. So next question is, when does the statute of limitations begin to run? When does the clock start ticking? It is the date that you default on the contract. So when you breach the contract, and that's usually when you miss the minimum payment. So if the minimum payment was due on, the first of the month, you missed it, you breached that contract, that's when the clock starts ticking. Now, there are things that you can do to restart that clock, and you want to be careful not to do that. You don't want to affirm the debt in writing, so you don't want to write anything, saying to the credit card company, saying that you owe the debt. You don't want to do that over the phone. You don't want to bring, well, you may want to, but if you bring the account back current, that would restart the clock ticking. And if you had made some minimum payments after you first breached it, that might be enough to restart the clock. So all things to keep in mind. When the credit card debt is sold by the original creditor to a debt buyer or another party, does that start the clock back over for the statute of limitations? Absolutely not. A debt buyer, a third party, if they buy your debt from the original creditor or from another debt buyer, it does not start the statute of limitations over. They're subject to the original statute of limitations, the original clock when you first breached the credit card agreement. So like I said, you don't want to affirm it again over the phone or in writing with any third-party debt buyer, because that potentially could restart the clock. So why does the statute of limitations matter? Like I said, it's the time that the plaintiff, whoever's filing a lawsuit, has to bring their lawsuit. If they miss it, if that 6 years runs out, you can use the statute of limitations as a defense. But guys, you've got to plead it in your first responsive pleading. You've got to put it in your answer. When you answer the lawsuit, you've got to say, the statute of limitations has run. They can't bring this lawsuit, something like that. You've got to raise it as a defense, or else you could potentially lose it. So definitely, if you think that there's a statute of limitations defense, if you don't know when you breach the contract, if you don't know how long it's been, if you think there's any way that the statute of limitations has run, you want to raise it in your answer. And I suggest that you hire an attorney to help you do that, because you may not only have a statute of limitations defense, which could get the case dismissed, you could also have a counterclaim. The FDCPA is the Fair Debt Collection Practices Act. That is the main federal law that protects consumers against debt collectors, and it only applies to debt collectors. So it doesn't apply to your original creditors, but a debt buyer, potentially a law firm that's bringing a case, anybody who's considered a debt collector under the FDCPA, you might have a counterclaim or a standalone claim against that creditor, or that debt collector. You might have a standalone claim in federal court against them. So if you think there's any way that the statute of limitations has run, I suggest that you find an attorney, you hire an attorney to help you figure that out, and to raise it as a defense and potentially as a counterclaim or a standalone claim. If you have any questions, feel free to give me a call at 404-594-5130, or find me on my website at parisifirm.com. Once again, the statute of limitations on credit card debt in Georgia is 6 years.